I'm Natalie Sanders. I'm an attorney with Brooks Pierce in North Carolina. In today's COVID-19 Connection video, I'm going to share with you information about the Equal Employment Opportunity Commission's new guidance on the return of high-risk employees to the workplace. First, though, let me remind you, this video is for educational purposes only. Watching it does not create an attorney-client relationship between you and Brooks Pierce. This video is not legal advice, and it is not a substitute for consulting your own attorney about your individual situation. The EEOC has been providing guidance throughout the COVID-19 crisis. In its latest in a Q&A format, it talks about the return of high-risk employees to the workplace. High-risk employees are those with an underlying health condition identified by the CDC as creating a high risk that person would suffer a severe illness or complication if they contracted COVID-19. In its guidance, the EEOC explains that excluding someone from the workplace solely because of that underlying health condition would be considered discrimination under the Americans with Disabilities Act. However, if returning that person to their position would create a direct threat of harm to their health and safety if they're returned, then it's possible that they may be excluded. But this is a high standard to meet, and it's an individualized assessment. How likely is the risk of exposure to COVID-19? What's the nature and severity of the harm? How imminent is it? Basically, they're looking at the very specific job and that individual to make those determinations. Even if an employer makes the determination that a direct threat exists, that's not the end of the inquiry. The employer and the employee need to go through a reasonable accommodation process. That's an interactive process where the employer and employee communicate well together to explore options that might eliminate the risk. The EEOC identifies some possibilities: telework, reassignment, personal protective equipment, or even a leave of absence. If the employee expresses concerns about returning to the workplace because of an underlying health condition, that is essentially the employee seeking a reasonable accommodation, and that process should be engaged. I hope you have found the information in this video helpful. If you have questions, please reach out to me at nsanders@brookspierce.com. I also encourage you to check out the Brooks Pierce COVID-19 Response Resources page. You'll find additional information about the EEOC's guidance, as well as guidance from other agencies on the return of employees to the workplace. Thanks for watching this edition of Brooks Pierce COVID-19 Connection. Take care and stay well.